Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session pursuant to adjournment. God save the Constitution and this honorable court.
Good afternoon, everyone. Can everyone hear me?
Yes, sir.
Okay. We'll call 1419-504 Bigbie v. State. Is everybody ready to proceed?
Mr. Bigbie's ready, Your Honor.
The state of Texas is ready, Your Honor.
Okay, and I see 3 minutes reserved for rebuttal. Is that correct?
That is correct, Your Honor.
All right, you may proceed when ready.
Thank you. May it please the court. Under the Anglo-American system of jurisprudence, a plea of not guilty is no more and no less than a request that the state put on its proof if it can. Under state law, there are 4 permissible areas of argument: a summary of the evidence, reasonable deductions from that evidence, a response to defense counsel, and a plea for law enforcement. Into which category did the state's argument fit? Here's what the state argued. Let me ask you about who has the motive to lie in this case. Is it Mr. Bigbie, who, if he lies well enough, doesn't go to prison? Is it Mr. Bigbie who has the motive to lie when he pled not guilty? Mr. Bigbie did not testify, therefore his credibility was never at issue. What this argument did was put his credibility at issue when he pleaded not guilty. It asked the state to believe or disbelieve him when he entered his plea. Well, let's look at the Lopez case. In Lopez, the court found incurable error despite an instruction to disregard, when the state argued that the lawyers who entered pleas of not guilty at the arraignment on behalf of Lopez and his co-defendant lied when they entered that plea. This case is worse than Lopez. This case doesn't talk about the lawyers and their credibility. It directly implicates Mr. Bigbie and his credibility. It touches on the presumption of innocence and on Mr. Bigbie's Fifth Amendment privilege not to testify, because what it does is requires him to come to the stand and back up his plea with evidence. In other words, you can disbelieve Mr. Bigbie's plea of not guilty. He lied. And since you didn't hear from him, so the implication arises, you should use that as evidence to find him guilty. In other words, we didn't hear from Mr. Bigbie backing up that plea of not guilty, so therefore he must be guilty. That's the implication here. In other words, Mr. Bigbie's being penalized for entering a plea of not guilty taking the stand. Had he taken the stand, he would have been fair game for argument that he did not tell the truth. But in this case, as we know from Lopez, an entry of a plea of not guilty is not sworn testimony, does not put the defendant's credibility at issue, and does not invite that sort of argument. The argument was manifestly improper. It touched constitutional issues of the Fifth Amendment's privilege not to testify and the presumption of innocence. And it harmed Mr. Bigbie, who was found guilty and given a life sentence, the maximum in this
Counselor,
case.
how do you respond to the state's argument that we should be analyzing this under Mosley? And could you also talk about how a Mosley analysis would affect how this case would be affected by a Mosley analysis?
Under either analysis, this case is beyond the pale. This case simply injects an issue into the case which the jury is not entitled to consider, which is Mr. Bigbie's credibility. In other words, it raises Mr. Bigbie's plea of not guilty to the level of evidence that the jury has to consider, and that's manifestly improper. So under any analysis, that's an improper argument. When you look at, for instance, when you look at Lopez, Lopez reversed, despite the fact that there was a timely objection, there was an instruction to disregard and a motion for mistrial. The same situation should obtain here. There's no way that we can see that there was a proper and timely instruction to disregard, but there's no way that can cure this kind of error. If so, then every defendant is liable for criticism when he enters a plea of not guilty. He's liable to have that used against him, so to speak, by a prosecutor who can argue that, well, this defendant didn't tell you the truth when he entered a plea because the evidence is, for instance, the evidence is overwhelming against him. This defendant didn't tell you the truth when he entered a plea of not guilty because we had an admissible confession. Where would it end? It has to end here. A defendant in Bigbie's position cannot be penalized for entering a plea of not guilty by putting his credibility in issue when he never took a stand. And under Lopez, this is incurable error. The only distinction, I think that there's a possible distinction between Lopez in this case, in that in Lopez, the argument was directly that Mr. Lopez's attorneys lied to the jury when they entered the plea of guilty. But this case implies the same thing. Is it Mr. Bigbie who has the motive to lie when he pled not guilty? That's telling the jury that he did indeed lie when he pled not guilty.
Could you give us a little bit of information or a little bit more analysis of the third prong of Mosley, the certainty of conviction absent of misconduct?
Well, here's the problem. Yeah, if you only, were it not for this argument, the defense could argue, free of any jury misconstructions, that the complainants did not tell the truth. That's a trial. That's what the trial is about. It's about the complainant's credibility. In this situation, in the back of the jury's mind is the fact that or the perception that Mr. Bigbie lied when he pleaded not guilty. Since he didn't testify, his credibility is in issue. He can't deal with that. He didn't give the jury any ammunition to believe that he was telling the truth when he pleaded not guilty. And therefore, you have now the jury weighing, counterbalancing credibilities, as opposed to just focusing on what they should have focused on. And indeed, the law requires them to focus on, which is only the complainant's credibility, since there were no other witnesses that could bolster or contradict that testimony. So the certainty of conviction would be undermined if the defense was limited to asking the jury to consider what they should have considered, which is the complainant's credibility and the complainant's credibility only. By taking the focus off of that and putting it on Mr. Bigbie, by implying that he lied when he pleaded not guilty, the state undermined that process.
Thank you.
In other words, it's easier for the jury to convict Mr. Bigbie when they have to consider his credibility, even though he never testified. And the jury did indeed do that, found him guilty, and gave him a life sentence. So that's what we're dealing with when we have the problem of the argument. That segues into my fourth point of error, which is also an argument problem. The argument was as follows: because the truth in this case is enough to convict. Complainant's truth in this case is all you need, but it's not just from her mouth. That is the lie that they're trying to sell you. This argument implicates counsel, because they were Mr. Bigbie's two lawyers, since Mr. Bigbie didn't testify. Or it may relate to the original argument a few pages before in the transcript that did talk about Mr. Bigbie's lying when he pled not guilty. There are two possibilities here. Number one, that argument complains directly about Mr. Bigbie not testifying. In other words, the lie they're trying to tell you is the lie that Mr. Bigbie is not guilty because he pleaded not guilty and you can't believe it. The other possibility is that the lie they're talking about, the state's talking about, is that it comes down to the complainant's credibility in this case. And the state raises that in their brief. That may be a more likely construction. We don't know. We're asked to speculate, but it may be. But that's bad, because that's exactly what is at issue: the credibility of the complainant here. Because when you all boil away all the other evidence, that's what, under the indictment, the jury is asked to believe or disbelieve beyond a reasonable doubt: the complainant's credibility. So now, that's what the trial is about. But now, when the prosecutor makes that argument, he says, no, that's the lie they're trying to sell you, that's what this trial is about. You're entitled to consider all the evidence, certainly, but it is not a lie to ask the jury to focus on the complainant's testimony and indeed find whether or not you believe that testimony beyond a reasonable doubt. That's what the jury instruction says. That's the law. And that distracts the jury from the law and asks them to consider other things and is prejudicial. So we have two back-to-back improper arguments. The first one is raised to the level of a constitutional violation because it implicates the Fifth Amendment and the presumption of innocence. Now, this other argument, a few minutes later, asks them to disturb the court's instruction, to ignore the court's instruction, and focus on other things other than the credibility of the complainant, which is what this trial is about, which is what every trial is about. So these arguments individually and mashed together are manifestly improper, could not be cured by a curative instruction, and the court abused its discretion in failing to grant the mistrial. The state talks about the Acosta case. In the Acosta case, which was affirmed, that was concerned argument about a dispute over the interpretation of a transcript of the defendant's conversation with someone. In this case, it's not a squabble over what the evidence means or what the evidence is worth or the weight of the evidence. It's actually an argument that counsel lied when he said that the issue in this case was the credibility of the complainant, which is what the trial is about. So Acosta can easily be distinguished here. That should not be, this court should not consider that a controlling case because the facts of that case are very much different. The argument in that case is very much different. So no, Acosta is not controlling here. If the court has no further questions on these 2 points of error, I'd like to discuss my first point of error, which concerns sufficiency. What the state has to prove in a continuing sexual assault of a child case is a 30-day period outside of which 2 enumerated acts are committed. No witness in this case testified to that. There was ample testimony that aggravated sexual assault of a child and other sexual offenses were committed. There's no question about that. But at issue here is the 30-day period. And no witness testified to facts which, if believed beyond a reasonable doubt, would rise to the level of conviction here. For instance, the state relies on witness Prihoda's testimony. She gives an age range in which it happened, of age 4 to age 6. She doesn't say when in that period of time any of these events happened, whether they happened within or without a 30-day period. It's all speculation that you're supposed to assume that it happened over an age range of 4 to 6, but she never says so. Witness Manning testifies that abuse occurred. She doesn't say what the abuse was. She doesn't say this act happened now, this act happened later, more than a 30-day period of time between those acts. That testimony simply never got into the record. Again, that just asks the jury to speculate as to what happened when and whether it happened outside a 30-day period. I would contrast Williams and Gutierrez. In Williams and Gutierrez, the complainant testified that more or less that it happened every day or it happened every other day, that sort of testimony. But there was extrinsic testimony from other witnesses that testified that, well, these complainants went over to this person's house for a period of 5 months every day. So you can connect it up. You can say the complainant says it happens every day. Well, every day the complainant was over at this person's house, for instance, in Gutierrez's house, for a period of 5 months. That would connect it up. But that was never stated definitely in this case by any witness. The complainant was very vague about that. And no other witness, no extrinsic witness ever said with any certainty that any enumerated act happened twice outside of a 30-day period. So what this court should do is reform the judgment to reflect a conviction for aggravated sexual assault of a child, which is a first-degree felony.
All right. I don't know if you could see the timer, but it's expired. So we'll deal with the rest on rebuttal.
I cannot see it, Your Honor, but I believe you.
Okay.
Thank you.
Okay. Sorry about that.
Yes, sir.
May it please the court. First, I'd like to offer my apologies to the court and to opposing counsel for my late supplemental responses. I hope that the court will take those arguments under consideration. Just briefly to respond to the sufficiency issue in regards to the time frame that was developed. That testimony was largely elicited through Carrie Prihota, the forensic interviewer. But she does testify that during the victim's forensic interview, she was able to describe specific acts of sexual abuse, and that she was also able to identify at what age those separate acts occurred. I'll refer to the victim as SC here, and Ms. Prihota did testify that SC was able to state that one act happened when she was 4, another when she was 5, and the last time that she had been abused, she was actually 6 years old. The acts that SC described to Ms. Prihota were all acts of aggravated sexual assault of a child. The first one that she described, she said when she was 4 years old, there was sexual contact between the defendant's sexual organ and her sexual organ. That is volume 4 of the record, pages 253 and 256. She also described oral penetration, and she said that the appellant would place his penis in her mouth, and she described the milk stuff that would come out, and then she also described anal penetration. She did say that all of those acts were happening more than one time, and she gave the age range from 4 to 6. So viewing that evidence in the light most favorable to the verdict, I think that the jury could certainly find that, yes, there was more than 2 acts of sexual abuse, and yes, these did occur outside of a 30-day period. To turn to the jury arguments made by the prosecutor, it's important to keep in mind this is an abuse of discretion standard, and mistrials are only warranted in the most extreme of circumstances. So here, beginning with the initial comment on the presumption of innocence, where the prosecutor asks the jury whether or not the defendant had a motive to lie when he pled not guilty. Even assuming that this comment may have been an improper comment on the presumption of innocence, as I argued in my brief, I don't think that, I think that the appellant's reliance upon Lopez versus State is misplaced here for a couple different reasons. The first of which is that Lopez was decided in 1973, well before the Mosley factors were developed to determine when a trial court abuses its discretion in refusing to grant a mistrial. If we do apply Mosley analysis, and I would encourage the court to do that, we first would look at the severity of the misconduct here. And here, even assuming that this question that's posed was improper, it's certainly much less egregious than the comment that was at issue in Lopez, where the prosecutor there did, make an outright attack, basically said something to the effect that you heard the lawyers for these 2 defendants get up here, plead not guilty, and they're lying to you. Here, the prosecutor, I think at most is insinuating that the defendant may have had a motive to lie when he pled not guilty, which again, may not be proper, but it's certainly less egregious than the comments that were at issue in Lopez, which not only attacked the presumption of innocence, but they were also an attack on the defendant over the shoulders of his attorney, and the prosecutor injected some very inflammatory facts that were outside the record into the case. And under the analysis that the Lopez court was applying at that time, that in and of itself required reversal.
Well, if we take the comments made under issue 3 and issue 4 together, could that not be seen as in the same vein, commenting on his, presumption of innocence and striking at him over the shoulders of counsel?
I don't think so, Your Honor. And the reason why is because these are 2 separate and unrelated arguments. They don't occur close together. And the prosecutor initially asks whether or not the defendant had a motive to lie. That's a separate and distinct argument from when he later argues to the jury that that's the lie that they are trying to sell you. If you look at the context of the second comment, excuse me, in the context of the entire argument, I think it's apparent that that argument is a response to the argument of opposing counsel. So these are two completely unrelated matters. And I don't think it's entirely clear that the second comment by the prosecutor is even an improper argument. If you look at the line of authority that deals with when a prosecutor crosses that line and attacks a defendant over the shoulders of his attorney, it can be a little bit murky. It's clear that the prosecutor, for example, cannot call defense counsel a liar. But the prosecutor certainly can attack the arguments that were made by opposing counsel. So the prosecutor can say things like, don't be fooled by defense counsel's argument. They can describe defense counsel's argument as ridiculous. They can describe counsel's argument as a smokescreen, and they can encourage the jury not to be hoodwinked by defense counsel's argument.
In this case, he actually uses the word lie. Is that right? He doesn't say smokescreen. He doesn't say hoodwinked. He says lie.
That's correct, Your Honor. And I would tend to say that using that particular phrase to sell a lie was perhaps not the best choice of words here, because the prosecution does have to be very careful to refrain from calling defense counsel a liar. The prosecution cannot explicitly impugn defense counsel's character. But I think, in all of those other instances where, say, for example, urging the jury not to be hoodwinked by defense counsel's argument, I think most of those arguments that have been deemed proper do involve a certain accusation to a certain degree of deceptive conduct by defense counsel. The reason that those were not actually improper is because those are not explicit attacks on defense counsel personally. Those were attacks on the argument that was made by defense counsel. So I think if you look at this particular comment by the prosecutor, the argument that defense counsel made in closing was that the state's evidence really just consisted of the testimony of the two little girls here, and that they were just not credible witnesses. So in response, the prosecutor was arguing, first of all, that the jury could convict the defendant just upon SC's testimony alone. And that secondly, the argument that that was the only evidence that the state had was the lie that they were trying to sell. It's not actually correct or valid. So while the choice of terminology was perhaps not the best, if you look at the gist of what the prosecutor was saying, he is attacking the argument of counsel rather than explicitly calling counsel a liar, which was the case, for instance, in Branson versus State, which was cited by the appellant. In that case, the prosecutor said something to the effect of, you heard defense counsel say X, Y, and Z. Well, he was lying to you. And then after the trial court sustained the objection and instructed the jury to disregard, the prosecutor immediately repeated essentially the same argument and said, you heard counsel say such and such. Well, that was a lie too. In that case, looking at the context of what the prosecutor was referring to when he said the defense counsel was lying, he was referring to opinions that defense counsel had voiced about the prosecutor's motives in how he had handled certain aspects of the trial. So it was apparent that the prosecutor was definitely not referring to the argument that was made by defense counsel. It was just a repeated personal attack. And we certainly don't have that here. Again, the gist of counsel's argument was an attempted response attacking opposing counsel's argument. And I would point out that even if we assume that it was improper, then I think the most instructive case would be Mosley versus State, where the Court of Criminal Appeals held that it was improper for the state to refer to defense counsel's argument as a rabbit trail and to say that the truth wasn't there. But the court found that that remark was actually still pretty mild, and it was ultimately harmless because that comment could be interpreted as not an attack on defense counsel personally, but an attempt to attack counsel's attempt to obscure the issues. And I think that's exactly what the prosecutor was doing here. Then if you take into account the other Mosley factors, there was, of course, a prompt instruction to disregard. We do presume the jury follows the trial court's instructions. And then in regards to that final factor, the certainty of conviction, I think the state's evidence in this case was extremely compelling and quite disturbing. Despite the fact that the victim was only between the ages of 4 to 6 at the time that this happened, she was still able to provide pretty graphic descriptions of various different acts of sexual abuse. She was able to describe what the appellant's penis looked like and what his semen tasted like. She was able to discuss things that a typical 4 to 6-year-old would not know. But I think what was perhaps even more damaging for the appellant was the fact that her testimony was not, in fact, the only evidence that the state had. There was another witness. Her older sister, MC, was also a victim, and she was able to corroborate SC's account of the sexual abuse. Their testimony was consistent with each other's. And there was no evidence that either of the girls here had any motive to fabricate the allegations of abuse. So I think if you look at all of the Mosley factors for each of the 2 comments that were made by the prosecutor here, any impropriety was not so egregious that it rose to such a level that the trial judge was not within the zone of reasonable disagreement when she determined that a mistrial was not warranted. If there are no further questions, that will conclude the state's argument, and I'd ask the Court of Appeals to affirm the judgment of conviction.
All right, thank you very much, counsel. Mr. Varela?
Yes, Your Honor. I can agree.
Hang on just a second. Let's get you back. Okay, there we go.
Can y'all see me?
Yes.
Thank you. I can agree with the state. The facts of this case are bad. I can also agree with the state when the state says that a mistrial should be granted only in extreme circumstances. If this case doesn't represent extreme circumstances, what would? What argument would the state have to make to impugn a person's plea of not guilty to get this court to reverse it? That's an open question. If this isn't it, what is? Under Mosley, under the 3rd prong of Mosley, if an argument like this won't affect the certainty of the conviction, what argument would? State's arguments are supposed to be limited to the 4 factors. This argument fits into none of. It was manifestly improper. It was severe. Let's compare it to Mosley. In Mosley, the argument was they want you to take, meaning defense counsel, not the defendant, meaning defense counsel. They want you to take a side road, a series of side roads, rabbit trails, and a rabbit trail that will lead you to a dead end. The truth is not there. That argument clearly fits into arguments about rabbit trails, smoke screens, hogwash. Those arguments are acceptable. The argument in this case that impugns a person's right to plead not guilty and puts his credibility issue is not of the same ilk. It directly impugns his constitutional rights to plead not guilty and put the state to its proof. What this court can do, this court has a fork in the road. It can publish an opinion that says that this sort of argument, while we condemn it, is not reversible. It's curable. That's a signal to prosecutors who may be of a mind to do so, to make the argument that was made in this case, that the defendant gave you a lie when he pleaded not guilty. Or the court can publish an opinion that says, no, this argument is outside the pale. The plea of not guilty is sacrosanct. It only involves the state in making its proof. It does not involve the defendant in a credibility contest. That's what we're asking this court to do here. Thank you.
All right. Thank you, counsel. Thanks for indulging the new electronic methods that we were forced to use during this time, and appreciate your patience. And cause number 14-19-504 Bigbie v. State is submitted, and we're adjourned.
May I be excused?
Yes.
Thank you.
Thank you all.
Thank you.